Good evening. We begin tonight with the Arkansas Supreme Court striking down a state law that was enacted just last year.
Act 975 mandated that constitutional challenges to Arkansas laws go directly to the Court of Appeals, bypassing circuit courts. Channel 7's Andrew Mobley has more tonight. Andrew.
The Supreme Court said in its unanimous ruling yesterday that with Act 975, lawmakers were trying to strip Arkansas circuit courts of their constitutionally assigned jurisdiction. The ruling's author, Justice Cody Highland, says the Constitution definitively establishes circuit courts as the original jurisdiction or first stop for all matters except as otherwise provided in the Constitution, which does not designate another court to hear constitutional challenges to state laws. He also emphasized that the Constitution makes clear that the Court of Appeals cannot be the first stop for such lawsuits by its very nature. Highland said Act 975 would transform the appeals court into something it was not designed to be, a trial court.
The problem with the act is that the Arkansas Constitution sets forth the roles of the different courts. Appellate courts are not designed to accept evidence. They're only designed to review evidence. So structurally, the proposal ultimately conflicted with the basic outline in the Constitution of what the different courts do.
In Act 975, lawmakers asserted that parts of Amendment 80 of the state constitution gave them the power to amend court jurisdictions. Specifically Section 10, which says the General Assembly has the power to establish jurisdiction of all courts, unless otherwise provided in the Constitution. Justice Highland said in yesterday's ruling that the state's argument depends on reading only the first half of that sentence.
What I think the legislature was contemplating was, let's see if we can redesign the system and still stay within the guardrails of the Constitution. And the Supreme Court said, well, try again.
So why did the legislature want to keep lawsuits against state laws out of circuit courts? High-profile laws by Arkansas's Republican supermajority or actions by Governor Sarah Sanders have been blocked or deemed unconstitutional in Pulaski County Circuit Court. Steinbuch says judges there have a political agenda.
Well, the Pulaski County bench is overwhelmingly far left and rules consistent with that. The legislature thought that they should come up with a mechanism that would allow these cases to go to courts that would actually judge matters on the law, not based on personal political preferences. The problem is that the method by which the law did it doesn't work, at least consistently with the requirements of the Constitution.
Act 975 went into effect in November, but its amendment to court jurisdictions was never adopted by the Arkansas Supreme Court. On your side, I'm Andrew Mobley.
All right, Andrew, thank you. To read the full Arkansas Supreme Court ruling, you can find this story on KATV.com.